Okay, welcome to this session. We have three really very interesting papers. We would like to leave some time for discussion. So the ground rule is 15 minutes per paper, which will leave us some time. And I'm actually going to put the timer on so a chime will ring at the end of 15 minutes. I did that last week for a talk that I was giving, and the chime rang and brought the talk to a rapid end thereafter. So we will follow the alphabetic principle by the first named author, which means that we start with Marianne Frank, then move to Barry Friedman and Brandon Del Pozo, and then conclude with Haley Proctor.
I guess that's my cue. Okay. Hi, I'm Marianne Franks, and I'll give you the title of my piece because I think it'll make clear what my intention here with this project is going to be. And this is a project that is very much in process. So the title of my piece right now is The Supreme Court as Death Panel. Subtitle, The Necropolitics of Bruen and Dobbs. And as the title indicates, what I'm going to be doing with my time is to talk about the import of the Bruen decision and to suggest that the only way for us to really process the entire import of the Bruen decision is to read it in tandem with the Dobbs decision that came out just the day after Bruen was decided. And the reason why I am suggesting that those two cases need to be read in tandem is not just because there are a lot of similarities between the two cases. And what I mean by similarities is that this kind of really mask-off kind of political extremism on the one hand, this very selective and tortured reading of history, this complete repudiation of precedent, all those things are true about both of these decisions. But I think even beyond all that, what I'm arguing for in terms of reading these cases together is to look at what I'm referring to as the practice of constitutional law as necropolitics. And necropolitics is just a fancy way of saying this is the politics of death. And this has a philosophical history. The way that one philosopher, Achille Mbembe, has described necropolitics is the capacity to define who matters and who does not, who is disposable and who is not. And what happens in a necropolitical society is that there are classifications between sovereigns on the one hand and people who are not sovereign on the other. And those people who are determined to be sovereign are allowed to have the right of self-defense, which I think is better expressed in many contexts as the right to kill, whereas people who are determined to be non-sovereign, to be those others, are two things. First of all, they are the others who pose a threat to the sovereign and therefore are likely to be killed by the sovereign. That is one part of being the other and the non-sovereign. The other aspect that I think is interesting, and that is the one that is illustrated in Dobbs, is that the non-sovereign, the other, is also denied their right, their most intimate rights to self-defense themselves. And so what I'm arguing for here is taking the position that pregnancy, as an objective matter, does present the risk of great bodily injury and death to the women who are pregnant, to the individuals who are pregnant, and therefore every pregnancy is a potential risk against which a person is entitled to defend themselves. But what we get in Dobbs is, of course, the absolute rejection of the notion that that is a constitutional right. So we hear that the right to self-defense in Bruen is this pre-existing, floating outside of time right, whereas the right to defend yourself against the most intimate form of risk of death or injury is something that has never existed. So pre-existing, non-existent, these two cases read in tandem. What is important to emphasize about the necropolitical society, too, is not just that one group of people gets to decide who lives and who dies, although that is an important part of it. But the corollary of this is also that those who are in power are the ones who are also entitled to make the lives of those others miserable, to terrorize them, to intimidate them, to make sure that they understand that their existence is contingent upon the power of the sovereign to let them continue existing. The fact that this is not something that the court makes clear, that it is an extraordinary aspect of the Dobbs decision where you hear the court say, This is different. Dobbs is different. Abortion is different because unlike all these other rights that are obviously legitimate and will never going to do anything to harm, abortion is involving the destruction of potential life. And that is a shocking thing to say under any circumstances, but it's particularly shocking the day after the court issues Bruen, which is entirely about the right to kill, which is entirely about the right to destroy life, actual life, not just potential life. So the provocative way to express my thesis here is that Bruen stands for the proposition that we are going to treat white men in particular as sovereign and expand their rights to kill and to injure and to terrorize and intimidate. And on the other end of the spectrum, you see that women, and in particular women of color, are denied even the most intimate basic right to defend themselves. That, I would argue, is really what is happening in the kind of necropolitics of the Supreme Court. It is to embrace fully and to double down on the racial patriarchy that does structure American society and always has. So just to say a little bit about how these two cases, I think, fit together and to elaborate a bit more on what I mean. With regard to the Bruen decision, as has been discussed earlier today, the real impact here is one, of course, that builds on Heller before it. And Heller's peculiar decision is peculiar in many ways, but one of the ways in which Heller is peculiar is the way in which self-defense is constitutionalized in this peculiar way that many other scholars have spoken about. That is, when Heller says, the Second Amendment protects the right of people to have and to use weapons inside their home for individual self-defense. This is shocking on a textual level because, of course, there is no reference to self-defense or the home or the individual in the Second Amendment. What there is a reference to is arms, and so that part maybe makes sense. But when we look at that as how it comports with the self-defense doctrine, we see that it is bizarre in one sense, because it is both narrower than what would be thought of in self-defense law and a lot bigger, a lot more expansive in scope. Specifically this, those of you who are familiar with self-defense law, and even if you're not, are probably aware of the Castle Doctrine. Castle Doctrine is intended to be a kind of relaxing of the requirements that one would need to show in order to legitimate their use of deadly force. So deadly force is supposed to only be used if it is necessary and if it is proportional for an imminent, unlawful threat of great bodily injury or death. And what is interesting about that, what is built into the concept of self-defense, popularly speaking, historically speaking, is a so-called duty to retreat, very commonly in many jurisdictions, and that is kind of folded into the necessity analysis. And the basic idea is, if you can leave the situation rather than killing or maiming someone, we'd rather that you do that. So a very important limiting principle to protect human life. Castle Doctrine is intended to be an exception to that duty to retreat, with the logic being fairly sound to say, yes, you should retreat in most situations, but not from your own home. And that is because your home is your own. It is something that you own. It is something from which you are able to exclude other people. It should be your last refuge. You should not have to abandon it. So when Heller says we are going to protect armed self-defense inside the home, in many ways it tracks what we're seeing in the Castle Doctrine. So there's that. But the Castle Doctrine, importantly, is not about weapons. There's nothing in the Castle Doctrine or self-defense law generally that says weapons and armed self-defense are meaningfully different from any other kind of self-defense. So it is narrow in that sense, and it privileges a certain type of self-defense above others. The other way in which it is doing something different than the Castle Doctrine is how much more expansive it is. Again, the notion that you are able to use deadly force in a situation that is imminent is something that happens in the moment and then is legally adjudicated after the fact, as we heard earlier this morning. When you say that someone has the right to possess, to purchase weapons in order to have self-defense in the home, this is an anticipatory notion of self-defense. I am going to plan for the imminent situation in which I will be forced to use this. And that's a very strange thing to think about. And what it also assumes, and we see this in Heller, is the assumption that when you purchase a gun, and I guess presumably because you say it's for self-defense in the house, we should believe you. And the question that I think we should be asking ourselves in Heller, given all the empirical evidence we know about what people actually get up to with guns in their houses, is it really true that people who are possessing and saying that they are using these guns for self-defense in the home are actually doing it? And this, of course, is work that people like Joseph and Riva and others have mentioned in terms of the terrorization, the intimidation, the use of guns in the home to do lots of other things than to actually act in self-defense. And that even when we're thinking about people who in good faith intend to only use those weapons for self-defense, it's a complicated legal concept. It is one that usually requires adjudication by experts. So even if people are genuinely thinking that they're keeping those guns inside their homes for self-defense, they may just be wrong about that. What's the upshot? Upshot is the constitutionalization of the castle doctrine in Heller is one in which the lord of the castle, and it really is a very gendered phenomenon, is basically taken at his word that the guns are there for protection and will only be used in those situations. When the reality is, when there are two people in that house and one of them wants to use a gun against the other, we know what the empirical cashing out of this will be. It is that the woman is expected to either be killed in her home or is expected to leave. The castle doctrine does not work for her. The first thing we ask domestic violence victims who in fact do kill their abusers is, why didn't you leave? Castle doctrine is inherently gendered in that sense. It provides that men are sovereign within their homes and women are subordinate. So when you constitutionalize that in Heller and you add to it that it is armed self-defense in particular, things get very bad very quickly. So what does Bruen do to this calculation? Bruen says we're going to take the castle doctrine and make it everywhere. So to the extent the castle doctrine says a man's home is his castle, he has the right to decide who lives or dies. In Bruen, we now say the entire world is the man's castle. He can do what he likes wherever he wants. And it is really hard to justify this on any logical grounds, especially considering the fact that the kinds of things that would have justified the castle doctrine simply don't apply outside of the castle. That is to say, inside your own home, does it make sense to privilege your sense of safety and your assessment of risk? Sure, for lots of reasons it does. Outside in the street, wherever one may be, should we privilege anyone's perception of threat and safety more than anyone else's? The answer should be no. And it should also be no because we know how it is that people are perceived in terms of threats and who is allowed to have weapons. What happens when white men want to put AR-15s on their backs and walk through streets? Nothing. What happens when a 12-year-old boy is holding what appears to be a gun, at least to a police officer who's ready to see a gun, especially if that boy is black? We all recognize that he is perceived as a threat. So regardless of what the letter of the law says, we know that what it means to be armed in public is definitely racialized, as well as being gendered in the context of the home. So the short version of this is to say, Bruen takes what happens in Heller and makes it so much worse, because now we're presuming, again, that the reason why people have and use and bear weapons is for self-defense. That's problematic enough within the context of the household. It is even worse when it comes to the world at large because of racial biases in terms of who is perceived as a threat and who is allowed to defend themselves. So what we have here is an expansion of what is essentially a paranoid, usually white, usually male mindset about others as being threats in a constant state of battle with other people. That is to say, everyone around you is perceived as an enemy who might be disobedient or disorderly in a way that will require you to use deadly force. That is the Bruen part of things. In the Rhode and the Dobbs part of things, what we see is, by contrast, this expansive notion that we've just gotten from Heller and from Bruen about self-defense. It is amorphous, it is everywhere, it is elevated, it exists outside of time. It could mean anything from I need to defend off an intruder in my home to I'm walking down the street and I don't like how someone looks at me. But when it becomes a completely self-contained, objectively validated view of a confrontation of a pregnant person and something that may kill or injure her, we say that has nothing to do with self-defense, and she is not even allowed, constitutionally, I should say, there is no constitutional right that she has to defend herself. And keep in mind, too, that that kind of intimate self-defense is not just key because it is, in fact, one's own body. It's hard to imagine a more intimate form of self-defense, but it's also harder to imagine one that is as publicly limited. In other words, when people go out with their guns, when people stand their ground outside in their neighborhoods, that becomes, in addition to the actual body count that it produces, it becomes a message to those who are perceived as other. We can control you, we can kill you, we will see you as suspicious, we will handle you if you are out of place. There is an element, once again, of terrorization and intimidation that accompanies this. A woman's choice within her own body about whether or not to terminate a pregnancy has none of those risks. And so it is one of the ways that we can actually see an empirical, pure self-defense case, and it is nonetheless precisely what the court says there is no constitutional entitlement for. Ultimately, then, I think these two cases read in tandem show us, or really reveal in a bare sense, how much of constitutional law is now necropolitical practice. It is solely about establishing who it is who is allowed to say who lives and who dies and on what terms. And it is also about deciding for certain people that they have no right to defend themselves, even against the most intimate and persistent and imminent forms of abuse. That, because I see that my time is coming up, that I think is a warning about where it is that the Supreme Court has decided to, what the Supreme Court has decided to embrace. We remind ourselves of Justice Jackson's warning way back in 1949 that we should not convert the Constitution into a suicide pact. My argument is that with these two cases, we have also converted it into a homicide pact. Thank you.
Wonderful. 10 seconds to spare. So, Barry.
Before you start your clock, I just want to introduce my co-author. Everybody knows me because we're here in New York, and I've been a law professor for 437 years. But Brandon is a PhD philosopher who works now in public health, but perhaps most interestingly for the paper, which is going to be about policing and guns, and spoiler alert, has the same racial effects as Marianne's, has been a cop for a long time, was the district commander of precinct we are all in right now, the 6th precinct, and also was the chief in Burlington. And so we're going to do I was going to say a heavyweight tag team, but I think we're going to do a bantamweight or flyweight tag team here. And Brandon's going to start.
Yeah, thanks. When the food didn't come, I just went around the corner to my old pizza place haunt and got pizza. There's half a mushroom slice if anyone wants to finish it. But now I'm up here. I got a frantic call. We're starting. Like, you would think, man, this guy's got guts. He's got no notes, no nothing. That's literally just coming in from eating the pizza. The last thing I'll say is, before I dive into the meat of this, is that my brother Eric Del Pozo's in the room. He works for the New York State Attorney General. He wrote substantive parts of the Bruen brief. So if you're upset that New York lost, it's like 40% his fault. He's right there. You can yell at him later. So we want to talk about what struck me in the first panel is the first panel was either directly about policing or directly up against policing in unspoken ways. But in my mind, anyway, it was all about policing, right? It was about arrests, about imprisonment, about incarceration, about creating sensitive locations by which the police could then subsequently make arrests. You had prosecutors and prosecutors' left-hand people up here saying, well, we are going to prosecute this or that, but what the police bring them, right? I mean, so it's not merely like we're going to go ahead and prosecute XYZ. Like, we will make those decisions from the ambit of what the police bring us in the first place, right? So I think it was interesting to see then us meander for the last few panels with some very interesting regulatory questions, but I think it's appropriate to return to policing. Maybe I'm police-centered, but I think Bruen is fundamentally about how firearms will be policed and what we do or don't allow the police to do. So back in the day in the NYPD, when I came on in the mid-90s, and I started on patrol in East Flatbush, I think there were 3 guiding principles to our work overall at a time when crime was very, very high, including violent crime. 1, all guns are inherently dangerous. 2, most guns are illegal. And 3, your job as a cop is to get guns off the street, right? And that worked, because if most guns are illegal and all guns are inherently dangerous, you have the right cause to go ahead and try to get those guns off the street. Back in the 80s, Vermont was the only state with constitutional carry. Now about half the states have constitutional carry. Bruen might not be as sweeping as you might think, because right now there are only 6 or 8 states that are shall issue states. And one way to may issue states. And one way to construe Bruen as the final death knell for those 6 or 8 remaining may issue states to align them with the 42 other states that already have something that Bruen was after. So there's something that Barry sent me a great quote that I'll read and then move on quickly from Harlan in Terry versus Ohio, right? And so when you look at Harlan and Terry versus Ohio concurring, he writes, if the state of Ohio were to provide that police officers could, on articulable suspicion, less than probable cause, forcibly frisk and disarm persons thought to be carrying concealed firearms, I would have little doubt that action taken pursuant to such authority would be constitutionally reasonable. Concealed weapons create an immediate and severe danger to the public. And though that danger might not warrant routine general weapons checks, it could well warrant action on less than a probability. So I want to draw your attention to his statement that concealed weapons create an immediate and severe danger. He didn't say illegal ones in the hands of the wrong people, one in the hands of someone with mens rea, period. They create a danger, and they might not warrant general weapons checks. If you look at the NYPD stop and frisk regime at its height, 685,000 stops a year, the NYPD could never say it because it was unconstitutional, but they weren't looking to say, my God, there's 685,000 cases of reasonable suspicion. One could argue that they were doing general weapons checks of the population. They were taking that last part of Harlan's proposition and operationalizing it until they were properly sued and forced to revise their practices under a monitor. So what we're seeing in Bruen, though, is a few things, and then I want to turn it over to Barry. But one, it's no longer clear that most or all weapons are illegal. And second of all, the suspicion that cops had when they see a bulge, when they see a further movement, no longer provides the cause to intercede on what they think is an objectively dangerous practice for the public and for them encountering armed people. And it was sobering for me when I went to Vermont as the chief of police for 4 years. I was told a person having a gun gives you criminal suspicion of nothing. So right now we have these epistemically verified risks, these empirically verified risks of more guns in the community. But legally we have this proposition that guns are not evidence of criminality. And that's coming into a collision course with like the last 2 generations of policing that at least in our cities are predicated on those 3 principles.
Okay, so what I want to talk about, before I pass it back to Brandon, is what has happened with the law, not with Bruen, by the way. I think Brandon and I agree on this, and it's important to emphasize, but with the legalization of the possession of firearms. So Brandon in our draft talks about how Bruen just does a mopping up operation, and I think that's accurate. So I want to talk about the before times and the after times. So back in the before times, as Brandon said, guns were both dangerous and, for the large part, unlawful. And that constructed what it was that the law of criminal procedure allowed of cops. So Terry versus Ohio allows cops to stop and frisk. I'm going to talk about the stop, then I'm going to talk about the frisk, and if I have a minute, I'm just going to mention some of the many other doctrines that are going to be affected by legal possession of firearms. But back in the day, so Terry says that officers on reasonable suspicion of criminality could stop someone to investigate. And though Terry involved the threat of what looked like it was perhaps an armed robbery, in many, many cases, as Brandon says, the crime itself is simply the possession of a gun. Whether it's a tip that somebody has a gun, the sight of a bulge, case after case concluded that cops, just on the suspicion that somebody had a gun, could stop them because that was criminal conduct. But that's not true, and courts pretty universally are now following state law. So here's just a snippet from a Third Circuit case. The Virgin Islands are in the Third Circuit, if you didn't know that. And at Carnival at the Virgin Islands, somebody tips off a cop that somebody's got a gun. They stop the guy, they frisk him, they find the gun, and he moved to suppress the evidence. And the court says, quite remarkably, listen to this, for all the officers knew, Ubiles was another celebrant lawfully exercising his right under Virgin Islands law to possess a gun in public. And they found after they got the gun that it had the serial number scraped off, that it was unlawfully held. And the court says, doesn't matter. The situation's no different than if the tipster had told the officers that Ubiles possessed a wallet, a perfectly legal act in the Virgin Islands, and the authorities had stopped him for this reason. Though a search of that wallet may have revealed counterfeit bills, the possession of which is a crime under United States law, the officers would have had no justification to stop Ubiles based merely on the information that he possessed a wallet. So same thing with guns now, which is the stop isn't allowed. There's some incredibly interesting ambiguity in the law, which we could talk about if there's time for questions, about how different licensing schemes might or might not allow police officers to go up to people and demand to see their licenses if they know that they have a gun. I'm going to put that to one side and just focus on the frisk. So the frisk is super complicated because the standard in Terry for a frisk is that the person's armed and dangerous. And the courts have completely split on whether armed and dangerous means armed is dangerous or armed but also is shown to be dangerous. So some courts hold that the possession of a gun is enough to frisk somebody, but many courts are increasingly holding that it's not. And one case that's particularly interesting that I'm going to mention is the Fourth Circuit had a case called Robinson. In Robinson, they get a tip that a guy's got a gun. They let him get in a car and drive away and stop them for a seatbelt violation. I will come back to that, but watch that. That's a pretextual traffic stop. They get him out of the car. They frisk him, and the debate is, can they frisk him because they think he's got a gun? And he says, that can't be right. You can't frisk me. In every state where carrying a firearm is a perfectly legal activity, every citizen could be dangerous and subject to a Terry, frisk, and pat down. The majority disagrees and holds that the very existence of a gun is enough to frisk somebody, and Pam Harris leads the liberal wing of the court in dissenting, saying that the law of policing is on a collision course with the law of guns. That's her word, collision course. She quotes Dan Hamilton from the Seventh Circuit. She says, as public possession and display of firearms becomes lawful under more circumstances, Fourth Amendment jurisprudence and police practices must adapt. And her view is, well, because the legislature legalized the possession of guns, we can't assume any longer that people that have guns are dangerous. So now you've seen the stop isn't allowed, and in many circumstances, the frisk isn't allowed. I could tell you similar stories about protective sweeps, about the Quarles public safety doctrine, about plain view doctrine, other doctrines in the law, but back to my partner.
Yeah, so going back to what Harlan wrote, and thank you for framing that so nicely, Barry, you have he was saying concealed weapons create an immediate and severe danger to the public. Now you have the court saying, quite clearly, no, to the contrary, when you see somebody who you think has a concealed weapon, this is a patriotic American, exercising their God-given right to do this thing that, thank God, was enshrined in the Constitution, right? It's no longer this, clear and immediate danger. And so I think what's going to happen is, a few things. It's interesting when you look at the census. So first of all, as an aside, as I hear people talk about sensitive locations, I have to remind you that delineation is not a magic elixir that will keep the gun out of that location. If you go to Chicago, there's the no gun sign on every privately owned business in the city, and yet it's floundering under a tremendous homicide problem. What this does, this sensitive location law, which my brother is defending the state in the challenges to that law, good luck with that. It empowers two things. Number one, the police to act upon somebody being armed in that location. But two, and more troublingly, it empowers somebody in custodial control of that location to alert the police, right? So in some cases, that's going to be a private business owner, a bar owner, cafe owner, whatever, the priest in a church. In other cases, if Times Square is a sensitive location, it will fall directly back onto the police. But the point is, when it comes to establishing reasonable suspicion, this has always been a subjective game in which the police have been given broad latitude to articulate what suspicion is. And the court, as Barry wrote, the court hates guns and loves the police. And I said, well, maybe it's the court dislikes guns or doesn't know what to make of guns and loves the police. But we both agree that as far as its rulings, this court tends to have a great affinity toward the police. So it wouldn't be a stretch to think that when the police engage in these articulations of suspicion post-Bruen, that's what will drive the enforcement of sensitive locations laws. That's what will drive the ability, even though there's constitutional or shall issue carry licenses, for the officer to nonetheless detain a person and conduct an investigation. And so what you have are things like, pretext stops going right back to the Wren court. You have things like, furtive movements, bulges, crime-prone location, drug-prone location, open crime pattern where the person matches the description. All of these things are heavily racialized. They fall along class lines. If there are sensitive locations in the Hamptons, are the bar owners of the Hamptons calling up the police to come and investigate an armed patron versus the bar owner, for example, in Harlem or Times Square or wherever? So I think what we're going to see is, one, the police leaning ever more heavily on the subjective articulations of suspicion, rather than the tried and true presumption that almost everybody carrying a gun in New York City is breaking the law simply by carrying it. Works for a while. If that no longer works, they'll say furtive movement made me nervous. He lunged for something. There were pre-assaultive cues. I thought he was casing for a robbery. All of those are quite subjective. And all of those will most likely, like I said, be racialized and fall along class lines. Those suspicions will not be levied equally. But the thought is that as these cases make their way up to the court, that the court will countenance these subjective assessments in a way that just gets us back to where we were with the initial problem of stop, question, and frisk.
Right, so that's the question. What are the courts going to do? Cops are going to act just like Brandon says, but what are the courts going to do about it? And we already have an indication somewhat. So first of all, cops are indeed relying on pretextual stops, so they can't stop because they have suspicion that somebody's got a gun. So they stop for seatbelt violations. They stop for registration on cars. They stop for all kinds of things. And courts are buying that. But far more interesting is, what are they doing about the armed and dangerous problem? Well, it turns out that, the gun doesn't make you dangerous. You need other indicia of dangerousness. And, the Idaho Supreme Court tells us Were there any bulges in the suspect's clothing that resemble a weapon? Whether the encounter took place late at night or in a high crime area, whether the individual made threatening or furtive movements. You can hear all over again all the stuff that drove stop and frisk in New York and Floyd is adding up to courts to sufficient suspicion. They believe the cops. There's case after case that we talk about where there's this one case where this guy walks into a shopping mall with a gun. Somebody says he's got a gun in his boot. The cops get a tip. They stop him. The cop says, well, I just asked if he had a gun and where it was, and he told me. And he says, well, he frisked me and got the gun, and the court was, well, we believe the cop. And, that stuff works. So, what's going to happen? I want to be on time, so I'm not going to talk about this amazing New Mexico case, but somebody asked. But, what we suspect is going to happen is, in fact, we're going to get these racialized effects. So I just want to read 2 quotes to you very quickly. So first, this is Justice Alito in Bruen. He's explaining, why this right to carry a gun. Well, some of these people who carry firearms live in high-crime neighborhoods. Some must traverse dark and dangerous streets in order to reach their homes after work or other evening activities. Some are members of groups whose members feel especially vulnerable. And some of these people reasonably believe that unless they can brandish, or if necessary, use a handgun in the case of attack, they may be murdered, raped, or suffer some other serious injury. Yeah, except those are not going to be the people that we let have guns. So Judge Harris writes in Robinson, the biggest concern is that these special burdens of people who fall on people who carry guns and can be frisked will not be distributed evenly across the population. Allowing frisks during traffic stops whenever someone is armed gives police officers unbridled discretion. And she says, again quoting Judge Hamilton, there is a potential for intentional or unintentional discrimination based on neighborhood, class, race, and ethnicity. And that is, in fact, what we see starting to happen in the cases and what we suspect is going to be the outcome. So what was before is going to be again now. We only had 7 seconds left, so Marianne's winning, but I'm pretty impressed with the panel overall.
Yep. And, no. Third pick, Professor Proctor.
All right. I hope I don't break the streak. So you've heard a lot today about the practical implications of the Bruen decision. I am going to be a little bit drier and focus on the jurisprudential implications. So as you know, Bruen changed the way that courts approach Second Amendment questions. Previously, the court would look at the weight of the burden that was being placed upon the Second Amendment right, and then based on the weight of that burden, apply a more or less deferential standard of review to the legislative policy that was supporting the law. Now, the court will examine the question exclusively based on text and history, maybe tradition, a little bit too. So this has led to the criticism that courts are no good at history. And so what happens when the court gets history wrong? Or more specifically, as the dissent asked, will the meaning of the Second Amendment change if or when the new historical evidence becomes available? So judges are not historians, and there is no question that the task that Bruen sets for them is going to be a difficult one. It will often require them to ascertain the significance and signification of documents that are very, very old. So there was, an examination of the Statute of Northampton. No, of course. Sorry. That better? Even closer. All right. The meaning of the Statute of Northampton, which is, of course, centuries old. Even for trained historians, the path to understanding these documents is strewn with perils. But the court, in its decision, challenges an important premise of this argument. So the dissent says, legal experts typically have little experience answering contested historical questions or applying those answers to resolve contemporary problems. But the court responds to that by saying, well, in fact, the day in, day out work of courts is to resolve disputes about what happened in the past. And that is in some part because our current law makes the law of the past relevant. It supplies the legal rule. And this is an observation that was made recently by Professors Bode and Sachs, and the court cites their article and says this: the job of judges is not to resolve historical questions in the abstract, as historians do. It is to resolve legal questions presented in particular cases or controversies. So cases or controversies demand answers. And as a consequence, legal historical inquiry is more determinate than abstract historical inquiry. And in order to achieve that determinacy, courts use various, and this is from the decision, courts use various evidentiary principles and default rules that settle controversies before them in the face of metaphysical uncertainty about what the actual historical facts were. So one of those conventions that courts use is the principle of party presentation. That is, that courts are entitled to decide a case based on the historical record compiled by the parties. Sometimes that historical record is materially incomplete. And this is the problem that Professor Tushnet was pointing out on the adversarial presentation of history. And so what happens when, through the adversarial process and the iterative adversarial process, it is improved? And so we arrive at the dissent's question, will the meaning of the Second Amendment change? Or put differently, should the first court's pronouncement on the meaning of the Second Amendment bind the court with the more complete historical record? Now, the principle of party presentation rests pretty easily with us when the factual dispute that the court is resolving is one of adversarial fact, the who, what, where, when, why of the dispute before the court. If the court is trying to decide whether the light was red when Jones entered the intersection, and Jones fails to put in evidence from a security camera showing that the light was in fact green, well, that's too bad for Jones. He may lose his case and he's not going to be able to relitigate that fact in the future. But future litigants who've had an accident in that same intersection are not going to be disadvantaged by the court's decision. The principle of party presentation sits less easily when the factual dispute that the court is resolving is one that underpins a legal rule. So if the court is deciding whether there is a historical tradition of regulating, say, the storage of firearms in a particular way, and New York, apologies to Eric out there, this is just a hypothetical, but if New York fails to submit evidence of an analogous state law from 1791 or 1868, well, that is too bad for any person who supports the policy of firearms storage that New York has adopted, because it means that at least within the relevant jurisdiction, all other laws are going to be litigated and challenged under the shadow of the ruling that's based on the incomplete presentation of the historical evidence. This conundrum is not unique to text and history cases. There are other varieties of interpretive rules that rely on facts to determine rules of law as well. So in Brown v. Board of Education, the court ruled that separate was not equal, in part based on psychological evidence of the impact that segregation had on Black children. Well, would new evidence that the psychological impacts of integration are more harmful change the court's answer? Some courts in the wake of Brown v. Board answered that question in the affirmative. I think in this instance, the question actually casts doubt on Brown's reasoning, as Professor Levinson pointed out, rather than on its conclusion, obviously. But the point here is that the problem of shifting facts is not a unique one to originalist methodologies. Any legal rule that is built upon facts is vulnerable to facts. So this becomes a question of stare decisis. This is what courts turn to when a party gives the court reason to believe that a prior legal ruling was incorrect. And I'm going to look at it specifically from the Supreme Court's perspective. So the modern doctrine of stare decisis holds that a court should adhere to precedent, notwithstanding a reason to believe that it is wrong, in the absence of special considerations supporting departure from that precedent. That was not always the way it was. Traditionally, stare decisis was weaker. It was thought only to operate within the zone where the meaning of the law was indeterminate. So it was meant to control the exercise of arbitrary judicial discretion within that zone of indeterminacy. But it was thought that where the law was determinate, the courts should apply the law. Thus, where a precedent was demonstrably erroneous, demonstrable because one could demonstrate the error with unambiguous indicators of determinate legal meaning, courts should not adhere to it. I believe that the demonstrably erroneous standard is best suited to accommodate the process of resolving successive cases or controversies under a text and history framework. I think it increases accuracy and legitimacy without meaningfully sacrificing stability. So, accuracy. To whatever extent one is concerned that the bounded historical inquiry in which courts engage is likely to lead to error, then one should value the ability to correct that error when parties come forward with evidence that it has occurred. Now, not all new historical evidence concerning firearms regulatory practices are going to demonstrate error. Isolated practices are not the same as regulatory traditions, but it is at least conceivable that future litigants will come forward to the court with new evidence that reflects the meaning of the Second Amendment that the court did not previously understand or apprehend. And the demonstrably erroneous standard would allow the court to correct itself, to correct its course, even in the absence of special circumstances justifying a departure from the prior ruling. Legitimacy. Advocates of a robust version of stare decisis place great weight on this value, arguing that courts undermine their legitimacy when they contradict earlier rulings. I think that this reliance is misplaced in a world in which we think text and history give determinate meaning. Under a strong view of stare decisis, courts must either openly resolve to adhere to a demonstrably erroneous interpretation of the Second Amendment, or else dissemble about what it is that they are doing. Neither approach should instill faith in the courts. By contrast, now that the court has frankly acknowledged that it is engaging in a historical inquiry that is bounded by party presentation, legitimacy would seem to call for equally frank error correction when that party presentation is shown to be incomplete. And then finally, the question of stability, because the problem with correcting errors is that it can be destabilizing. On the force of the Bruen Court's guidance, 6 states in the District of Columbia will presumably rework their licensing regimes to rely only on objective criteria. And the discussion of the various panels today show that this is no mean administrative feat. One might well believe that the loss of stability is worth getting the Constitution right. After all, one would perhaps hope that future New Yorkers would be able to elect representatives who enact discretionary licensing regimes if that is in fact something that the Constitution allows the states to do. But change does have costs. I just don't think that these costs are going to be all that large in text and history cases. That is, that I think that the shortcomings of the court's historical inquiry are overstated. Yes, especially initially, there is going to be confusion about what exactly it is that the courts are doing in applying Bruen's methodology. But again, Bruen's methodology is not actually all that unfamiliar to courts. Courts often engage in historical inquiry about the meaning of the law in the past, and they often engage in reasoning by analogy. That's what you learn as a 1L in law school. How is this precedent different from that precedent in a way that's material? One important reason for this is that the historical record that is relevant to legal inquiry is finite and static. It consists largely of sources that are comparatively easy to access. They're namely government records, so we're not talking about some dusty scrolls that are buried in the desert somewhere. And any evidence that bears on the court's inquiry into text and history already exists. It is true that future litigants may discover evidence that already exists but is currently unknown, or courts may learn to understand old evidence in new ways. But recall that the sort of inquiry in which the court is engaged in Bruen is discerning the shape of a right to keep and bear arms based on its reflection, more or less contemporary practices. So it's going to take more than an isolated example or a small shift in perspective to really change the picture of what that right is. And my litigation experience in the Second Amendment area has borne this out. Take the example of the question of whether 18 to 20-year-olds enjoy a right to keep and bear arms. That is a question that has not even made its way to the Supreme Court yet. And yet the evidence for and against that right has not changed meaningfully during what is essentially a decade of vigorous litigation. When a panel of the Ninth Circuit recognized the right earlier this year, it relied on much the same evidence that Judge Jones cited in her 2014 dissent from denial of en banc review in which she recognized the right. And that was an opinion written only a few years after the Supreme Court's decisions in Heller and McDonald. So my point is that it does not take very long, as long as we might think, to figure out the methodology and to figure out the historical evidence. So compare all this to, I'll be brief here, but compare all this to what you've heard today about the practical consequences of the Bruen decision. Just from my fellow panelists, you hear about the deeply empirical questions about what the potential racialized impacts of the Bruen decision are going to be. What distinguishes the history-based inquiry from balancing tests and means and scrutiny is that the former look backwards, while the latter look forward. These empirical questions depend upon an ever-shifting body of evidence about what the effects of various legal policies are going to be. As a consequence of the difficulty and the empirical nature of these questions, courts often opt to be deferential to the legislatures, but recall that we do have a right codified in the Constitution. That means that the legislature can't be the one to make the decision in every case. And so in situations where the court is actually enforcing the right against legislative policy, the court, under a means and scrutiny or balancing test, is truly basing its decision on shifting sand. And text and history, by contrast, offers more stable ground.
Thank you. Okay, let me offer some brief comments about three really interesting papers, and then I certainly anticipate we'll have time for some questions. And those of you who do want to participate, the microphone is over there, and you might start congregating sooner rather than later. Just going down this row, I increasingly define myself as reverting to my initial identity as a political scientist rather than being a lawyer. And I thought that your paper is really superb in that it obviously talks about law, includes discussion of cases and the like. But I think it is really a wonderful piece of law and political science. That is to say, how do judicial decisions get translated into actual behavior of complex institutions with their own scripts, their own practices, their own routines, but also their own agreement or disagreement with what their ostensible superiors want them to do. I mean, even if they agreed with it, we know that institutions are hard to shake from established routines. I think one of the best books ever written by Seymour Saracen, sociologist of education, called, I think, The School and the Problem of Change, pointed out that one of the reasons it's nearly impossible to change the actual behavior of public schools is that the teachers with tenure have seen reformist superintendents come and go. You can make the same argument with regard to federal bureaucrats protected and properly protected by civil service laws. They can outlast any of the reformer secretaries of this, that, the other, if they have any doubts about the reform program. And it seems to me that the brunt of your paper is that, quite frankly, it's going to be very difficult to find any institutions that don't have severe doubts about this program enunciated by maybe 5 justices, but we're 6, but we're also told that the cognoscenti really should read Justice Kavanaugh's 2-page concurrence, because that's the real opinion rather than the endless opinion of Justice Thomas. And who knows? I mean, that will be seen in the future, but it does seem to me that your paper raises all sorts of wonderful questions, not merely about how to crunch cases. Are guns always dangerous or only in the hands of bad people, as you often hear in Texas. There are good people with guns, and those are good guns, and there are bad people with guns, and there are bad guns, but also the institutional context. I think your paper really brings out wonderfully. With regard to Mary Ann's paper, which I also think is really, really fascinating, in the previous iteration of this symposium, the essay I ended up writing was about notions of sovereignty. And I think that is absolutely central to both of the cases that she talks about. I increasingly believe that Justice Thomas and Justice Alito are Hobbesian anarchists in certain ways. That is to say, the picture they present of the society in which we live is Hobbesian, the war of all against all. It is completely rational to be fearful that you're about to be attacked at any time, and that you need a gun, basically not quite everywhere and any time, because there are, the special places, and we have no idea, the sensitive places, we have no idea really and truly what they are. But otherwise, you really should be fearful. And unlike Hobbes, who did find a solution to that problem, which is the state, or, even if you're a Lockean, it's popular sovereignty, the ability of we the people to make rational laws about how to handle the genuine problems of security. They're not made up. You don't have to be a paranoid. But that is what Hobbes and Locke is all about. But I think that Thomas and Alito really are at bottom. I mean, they're both hard to figure out because in the national security cases, they're statist and Schmittians. But in this particular area, I think they really do have overtones of what I'm calling anarchism. And I mean this respectfully. I've known Eugene Volokh for a long time. I think he's brilliant. I like him very much personally. He's also one of the leading libertarians in the legal academy, as is Randy Barnett. And one of Randy's essays rejects popular sovereignty in favor of individual sovereignty. And if you believe in individual sovereignty, then the state shouldn't be able to tell you that you can't carry your gun with you wherever your feet might feel, threatened. And I do think that there are these really interesting differences between libertarians and statist conservatives. Now, then you get to Dobbs, you get some of the national security decisions, and Alito and Thomas are thoroughly statist conservatives. But that speaks to the tensions in their own view. And one wonders who the sovereign is in the case of pregnancy. It's not pregnant women. Is it the fetus? Well, not completely, because the fetus does not have the right to kill the host mother in order to protect the fetus's survival, which might, in fact, on certain number of occasions, I think you referred to a cesarean case, could be true. So we say that even the Supreme Court says, well, if the fetus really and truly is a threat to life, not merely a threat to health, not the kind of insecurity you might have when you enter a high crime area and feel anxious, but the fetus really does have a right to inflict great damage, but not death. And so I have no idea who the sovereign is in describing that, but I do think that the language of sovereignty is really very, very important and relevant anytime one is discussing quite literally life and death. With regard to Professor Proctor's paper, which is also very interesting, I'm going to say I don't share her confidence in the liquidation through case-by-case analysis. But what I want to point out, and I'd be interested in her own response, one of the things I really detest about Justice Thomas's opinion is its, I think, historical fabrication. So that reading from page 2133, as we stated in Heller and repeated in MacDonald, quote, individual self-defense is the central component, italicized, of the Second Amendment right, unquote. My own view is that that's demonstrably false. I actually support the decision in Heller on Ninth Amendment grounds or perhaps privilege or immunities grounds, but it seems to me that the soundest historical research on the Second Amendment, drawing particularly, say, on the book by the late Professor Richard Uvler and others as well, is that it has to do with civic republicanism and the right of an organized people to rise up against tyranny. So if I really were talking about history, quite frankly, I think I'd feel more comfortable defending some of the January 6 folks who genuinely view, sincerely view, the current government of the United States as tyrannical and justifying being overthrown by force and violence, and talking about 1776 and Shays' Rebellion, than I would about an ordinary self-defense case, which I might defend on grounds of Ninth Amendment or the inchoate views of the people, but not as Second Amendment. But here you have what I most really have grown to detest about the modern Supreme Court. This is what philosophers call performative utterance. They just make up what the central meaning of the Second Amendment is, citing themselves. And then, because we are socialized into a culture of viewing the U.S. Supreme Court as, quote, the last word, unquote, in constitutional interpretation, impressionable students and others are just led to believe, well, this just is the central meaning of the Second Amendment, and you don't have to engage in independent historical research or show that other people beg to disagree, unless, of course, some future court says, and it isn't even new research, it's saying we have this literature about 18th century civic republicanism and the linkage between the Second Amendment and civic republicanism, and this earlier decision was wrong. And so, I would compare this to Reconstruction, that the court of the 40s and 50s grew up in an historical era. Reconstruction was an evil, it was corrupt, this, that, or the other. You had these remarkable transformations among professional historians about Reconstruction, Kenneth Stamp, many, many other people. And most of us, though not all of us, the majority of the Supreme Court, as far as I'm concerned, even though John Roberts majored in history at Harvard, has no genuine understanding of the importance of Reconstruction. For him, the founding is all about 1787. Reconstruction is a kind of blip that does not, in fact, transform legal reality. So I confess, I just don't have faith in the people likely to become Supreme Court justices to engage in the kind of careful, scholarly inquiry you're talking about. And I certainly don't have faith in the adversarial method, motivated reasoning all the way down, that, as scholars, we would like to think that we examine issues at least a little bit independent from short-run political interests or agenda interests, and we'll publish our stuff even if it's uncomfortable to certain political or ideological views we might have. But no lawyer operates under that notion. The job of a lawyer is to engage in motivated reasoning, and then you have to hope that judges will have certain kinds of antennae or talents to see through the motivated reasoning. But where would they get the information from if they're really relying on adversarial presentation? Maybe from the amicus briefs, but we could have a separate panel on the reliability of amicus briefs. But in any event, I think all three of these were fascinating papers, and I do think we have some time for questions, comments, and whatever. And you should go over there to the microphone, since this is being streamed, or just an opportunity while people are going over, if any of you want to pick up, or all of you want to pick up.
I'll
Please.
claim the right of self-defense here and defense of Justice Thomas. So I am not at all qualified to do battle with Professor Levinson on history, so I'm not even going to try. But will, have a few observations about methodology in light of the very real historical disagreement that he's highlighting, which is that there is disagreement about the history in Heller and the history in MacDonald and the history in Bruen. And the mere existence of historical disagreement, though, does not necessarily mean that the law is not determinate, that it doesn't have some meaning that with adequate historical inquiry we could discern and uncover. And a corollary to that is that the fact that the law is determinate doesn't mean that the court's not going to get it wrong sometime. I think the court's right here, more right than it is wrong. But I do think the court does get things wrong, and if we accept the fact that the court's going to get things wrong, that in itself supports a weaker approach to stare decisis, number one. And number two, a real comparative analysis. We're not just dealing with historical inquiry as the only option here, right? The alternative was an empirical inquiry, and just as the court isn't made up of historians, it's also not made up of social scientists and empiricists and people who really are expert in the sorts of policy judgments that the court had to review under means and scrutiny. And I think that within the realm of empiricism, because we're dealing less with a concrete historical record and more with this unbounded and ever-changing universe of potential data points, there's much more room for the sort of performative utterances and for the sort of motivated reasoning. And then a final defense of the adversarial process. Yes, I think that there is motivated reasoning, but the whole point of an adversarial process is that you have two sides engaging in motivated reasoning against one another, and our theory, at least, is that is more likely to lead to a discovery of the truth. So, and then finally, Justice Thomas and Justice Alito, one thought I'd like to put out is that if there is an incoherence in their political theory, then that may suggest that what they're doing is not political theory and is in fact law, that the Constitution actually points in different ways in those areas.
Very briefly, I wanted to say two things. One, I love this idea of a regression to anarchy, because one of the things I've been toying with is if you read Anarchy, State, and Utopia by Robert Nozick, the first book is about the transition from anarchy to the state. The two books that follow are about the transition to utopia. We haven't gotten there yet, so let's look at the first book. If you read that book backwards, you're getting what's happening today, from the state back into nature. A dominant protective association being dissembled, so now you have competing tribal protective associations, and then those competing tribal protective associations have like cantankerous members that want their own power, so then it becomes individuals now being their own protective association, maybe with their family, and that's called Hobbes, right? And I see that happening in the court, and it was sad, but so the title of the first book is How to Back into a State Without Really Trying. The subtitle of reading it backwards is How to Back Out of the State Very Deliberately Through the Supreme Court. But the other thing I'll say about the adversarial process, so I do have my PhDs in political philosophy, and I'll say this briefly. Once I wrote a book called The Police and the State, I said, I've answered all the questions normatively to my satisfaction. Now I want to know the evidence, so I went and got a postdoc in substance use and public health research at Bruen, so the taxpayers are paying for all of that. But it was because I found that when we're talking about producing knowledge, the adversarial approach is not how science produces knowledge. If you want to get an NIH grant, what you should never do is read all of the dominant research and then send them a grant and ask them for $1 million and say, I'm going to just make a counter argument to everything you've discovered in the last 40 years, very impassionately. It's about this like process by which iterative discoveries like coalesce into reliable knowledge. So I will say that I do, now that I'm studying this, find it peculiar that the court's approach to knowledge, which is like smashing atoms and seeing what happens from an adversarial perspective, is just not what I've had the privilege of like learning how science happens, which I do trust to produce knowledge. So thank you.
Marianne?
Yeah, I'll just say quickly that on this question of who's the sovereign when it comes to with the question of pregnancy, one thing I do want to highlight, I'm not sure what the answer is to that, right? That it seems like the main point is that whatever the case is, the pregnant person is not allowed to be the sovereign, and that the Roe to Dobbs decision is so troubling in part because Dobbs is so bad, but so was Roe. And one of the things that's so bad about Roe is that the decision is medicalized, that it is the person who is most appropriate to be the arbiter of whether or not this pregnancy should continue should be, presumably, the male doctor. And that not much has changed, except that the court has said, not even that, right? That whoever this decision should be outsourced to, it should be someone who is, the last person who is qualified to be that arbiter is the pregnant individual herself, and that we need to make all these determinations. The one that keeps sounding so rational, that is to say, well, obviously if the pregnancy is going to kill her, we'll allow her to have the abortion. It just rings so, there's such a poignance to it in some ways, because you see in Bruen, the court saying you can't possibly demand of people they show a special reason for exercising this right to kill other people, right? But when it comes to a woman deciding that she wants to terminate her pregnancy, she needs to show us a really good reason. And that same instability about what does it mean to defend yourself and have legitimate force is so, I think it's mirrored in this question of what is a true threat to the life of the mother, right? We talk about that as if that's a real thing, that we know that in advance, that we can point, right? So there's a 20% chance that she will die because of this pregnancy. Is that a true threat or not? And so every time that is trotted out as this kind of outer boundary for this denial of abortion rights or this forced pregnancy idea, we really need to ponder the fact that that's a moving target, as it were, right? The idea that we get to decide, some establishment, some other official gets to decide whether the pregnant person is in enough danger that we will then say, well, we're going to let you defend yourself in this case.
All right, so I have the unfortunate duty of calling time now, but I really want to thank the panelists, thank NYU. This is actually exactly the kind of thing that we were hoping, a very broad discussion with people from different disciplines, different experiences, a very deep discussion, going really into the depths of these really interesting papers. Really look forward to their publication by this great journal. Thank you to the editors. Thank you to NYU. We do have to vacate this building at 2, so lunch is available, but it's grab and go. But at least we all don't have to share Brandon's pizza. So, thank you.